Okay, this is Paul Previte again. We're going to talk about bail bonds in Texas, and primarily here where I practice in Tarrant County, the Fort Worth area. Bail is generally something that you're entitled to, and not just bail, but a reasonable bail that is meant to assure that you're going to show up for court. There may be conditions attached to bail by the judge that would have the best interest of society at heart, such as in a DWI case, if you have a high alcohol concentration alleged, they may require an interlock in your car, which would prevent you from starting the car with any kind of alcohol on your breath. So, those kind of conditions are meant to protect the public, but the primary reason for the bail is to get you to court, make sure that you're going to show up. And if you don't, then the bail money that's posted either by you or by an attorney like me or a bail bondsman is going to be forfeited to the state. So that's the first and primary function of it. How much is the bail going to be? Well, really, there's no definite number. In Tarrant County, there's a schedule for bonds. You can get up to, unlimited. It could be $1 million. But for most cases, you're looking somewhere between $500 and $25,000 for most cases. And that assumes you don't have a real sordid history, long, lengthy criminal record. That kind of thing can affect the amounts that the judge is going to impose on you. But for most cases, you could look in that amount. And for the vast majority, most do not go over $10,000, generally speaking. How much you're going to be charged? Now, you can post the whole $10,000 yourself. That's called a cash bond. If you do, you might get that money back at the end of the case, assuming you've showed up and done what you're supposed to do. Otherwise, many times you'll pay somewhere between 10% and 20%, depending on if it's an attorney or a bondsman and who they are. Everyone's got their different prices. I myself generally charge 10% if you have a fairly clean record, and I apply half of that amount that you pay me, 5%, to your attorney's fee. So it's like getting a 5% bond, which is, in my opinion, a pretty good deal. Now, you do have some requirements with that. You'd have to show up and or call my office once a week. There's some other rules that we have to go over. You're not really supposed to leave North Texas. And assuming you do all that, just check in. I stay on your bond. We keep on going to court, and I represent you in the case. Now, what if your loved one doesn't have any bond? In some cases, a person's on probation, and the state files a petition either to adjudicate, that is to find them guilty if they're on what's called deferred adjudication, or it's a straight probation and they just want to have you sentenced. So in the case of a deferred adjudication, you are entitled to a bond. In the case of if you're on a straight probation, you are not. We'll take the deferred adjudication first. In that case, you are entitled to a bond, and what has to happen is the attorney needs to go in and we need to talk to the judge and try to get a bond set. Many times that may be double the amount of the bond that you initially paid before you were placed on probation. The judge will require before setting a bond that you are current, and this goes for straight probation as well, that you're current on your probation fees, you're current on your fines and court costs, and you don't have to be paid in full, but you have to be up to date on those costs. Once that happens, the judge in most cases will set a bond, and then we can undertake the filing of the paperwork that will actually post the bond with the county, at which time you'll be released. If you have no bond because of probation and we get one set, you won't be released directly. You may have to be released to the probation department, which could be the next day or a few days later. Worst case scenario, if this happens on a Friday, for example, you wouldn't be able to be released until a Monday. The 10% fee sometimes can be paid out, but again, 5% does apply to your attorney's fees. Now, there are cases where no bond is set. It's not because of probation, and we need to undertake other steps. We can file a writ, it's WRIT, with the state, get it to a judge, and assuming you qualify, there's a number of legal rules that we have to follow, but assuming you apply, we can get the judge to then set a bond immediately and get you released. So if you have any questions or you need a bail bond, call me at 817-335-4357. Thank you.